You are good to go.
Great. So I'll call the meeting to order. Next, determine if the quorum is present, and we do have a quorum. We have 3 out of 3 here. Decisions by the board are made by majority vote, so that would require 2 out of 3 for any particular vote. The board does have power to grant variances as well as to entertain appeals. And in this case, where it's a variance that's before us. And we're doing that pursuant to Maine statutory law and the zoning ordinance, or the ordinance of Waldeboro. In these matters, the applicant has the burden of proof. So you have to have enough evidence to, carry the day in terms of presenting information to the board upon which the board can make a reasonable decision. So what we would do next is we'll do a summary of where things were based on what we've seen, and then we can get into the details as another step after that. So the matter before us is that the New England Annual Conference of the United Methodist Church is requesting a variance. They're attempting, I'm just going to read this. New England Annual Conference of the United Methodist Church, owners of the property at 8595 Friendship Street in Waldeboro, are attempting to sell the property. It's become necessary to divide the property in order to sell it. One parcel to contain the former parsonage and the other to contain the church building. The proposed lot plan for the former Methodist parsonage complies with all the applicable standards. However, the retained land, which includes the former church building, does not. The latter structure does not meet the 15-foot side setback requirement. It only has 12 feet, and the retained parcel does not contain 75 feet of road frontage. It has only 68 feet. There is no way to draw a new line that will allow both lots to comply with the side setback and road frontage requirements. It appears that the only way to deal with the issue is with a variance, which is the purpose of the application. So that's the general description. Next, I need to determine if any members of the board have a conflict of interest in this matter.
Oh,
So here, no on all counts. The next matter is the standing of the applicant to bring this matter before the board. And from the materials that we have received, the ownership of the property based on the deeds that we have received is in the Waldeboro Methodist Church. But the applicant is the New England Annual Conference of the United Methodist Church. We have received an affidavit from the United Methodist Church indicating that it has the power to sell, but we have not received anything from the Waldeboro Church indicating that they've transferred the property to the conference, or authorizing the conference to to control the use and disposition of the property. So at this point, I invite comments from the other board members to see if the applicant has met its burden of proof, and certainly if they would prefer to hear from the applicant, that would be fine too. So either way.
I haven't had a chance to review the attachments to the affidavit. It seems to me from the affidavit that if there was a vote of the local parish to dissolve, that the transfer of title is automatic.
Is there a vote? I didn't see a vote in the materials.
If you look at, excuse me,
Please.
thank you.
The first,
And could you identify yourself, please? for
thank
me?
you. Would you rather I?
Yeah.
Either way, whatever you'd like, whatever you're comfortable with. Or casual.
Great, me too. My name is Mark Mancinelli. I'm the president of the Board of Trustees of the New England Conference of the United Methodist Church. On that, what is titled Certificate of Succession, if you look at the fourth page, at the bottom, it's a photocopy of a part that comes from our book of discipline, which within Methodism is sort of the code
Yeah.
ordinances for our denomination. Bottom of that page, it would be actually 2549.1B. Upon recommendation by the district superintendent with the consent of the presiding bishop, a majority of district superintendents, the appropriate district board of I lost my place. Board of Church Location and Building, the annual conference may declare a local church closed. If the annual conference closes a local church, title to all the real and personal, tangible and intangible property of the local church shall immediately vest in the annual conference board of trustees. Shall hold said property in trust for the benefit of the annual conference. And if you look at the next to the last page in that packet, the top of the page says RS 21202 to close the Waldoboro United Methodist Church. That is the record of the action of the annual conference on Thursday morning, June 10th of this year. And that vote went into a long explanation of your question. That vote is what declared the church closed. And by the discipline, by our code, it reverts to the annual conference and the trustees of the legal body of the annual conference.
I just didn't see anything from the Waldoboro Methodist Church authorizing you to take those votes.
The Waldoboro Church took its own vote, and I noticed that myself. That does not appear in that certificate of succession.
Right.
But they have, and I honestly don't know the date of that vote. I don't know the date. It was sometime during this calendar year, and I know it followed a period of discernment for them, but I can't tell you the exact date, nor do I have a copy of the minutes of that meeting.
All right, so that's the problem. The title, the record title owner, we have no trace of, from my perspective, we have no trace of their having authorized, the conference to do this. Be like my employer trying to sell my property because I'm employed by him, and there's no deed for me to my employer. So that's kind of what's missing.
Yep.
At least as far as I can see at this point. Yeah.
I agree. I think that's in order to establish that we can make further decisions here. That's my thought.
I agree.
Yeah.
I mean, basically, we need something from the managing board of the local church, that they took this vote. And then it seems to me, under the conference protocols or rules, that triggers the rest.
Absolutely.
So at this point, you don't have standing to bring the application. And I'll try to get that. What the next step will be. Shall we wait until we have that evidence? Do you want to proceed to the next set of discussions and make it a condition? What's your pleasure?
Over here.
Yeah, I agree. We're here. We could entertain the discussion
All right.
about it. We're here.
So that's what we'll do next then. So the next question is, if you could get that for us.
I will, absolutely.
Next question is if the board has jurisdiction here to grant the relief requested. Couldn't, so in that, with respect to that, we have, as I indicated, authority to grant variances. But it looked to me from the application materials that you were asking us to redraw the boundary lines. Some issue about, is it one lot or two? But in either of those cases, the sketch you provided has a different set of boundaries, and we don't have authority to grant that. It's not within our power, nor is it in our power to divide the land at all. That's just not, I mean, it's not our jurisdiction. So that's my observation. Now, I don't know what my fellow board members' views are on it, because these are votes, you know, by two out of three and so forth. So if you take a look at that plan from Kendall M. Black, or with his name on it, you're trying to carve out a piece and of the single lot, or a piece out of maybe one of the lots. I'm not sure if there are two lots instead of one, which isn't clear yet. But either way, we don't have that authority to do that. In my view.
Well, it seems to me that the derivation of these properties were two separate deeds. I mean, there's a deed in 1850, whenever.
Yes.
Relating to the property on which the church structure is standing. And there was a deed in 1962, I think, which was confirmed by a second deed in the 70s for the lot on which the parsonage is located.
Yes.
So the question is, do we have one lot or two lots here for purposes of the zoning ordinance? I've looked at, can I read from this?
Please.
Section 4.6.2 of the zoning ordinance titled the contiguous building lots. First paragraph says if two or more contiguous lots or parcels are in single or joint ownership of record at the time of the adoption of this ordinance, part of the lots do not meet the dimensional requirements of this ordinance. And if a principal use or structure exists on each lot, the non-conforming lots may be conveyed separately or together, provided that the state minimum lot size law and state main subsurface water disposal rules are complied with. So looking at this plot plan, it looks to me as if the boundary between the church and the parsonage differs slightly from the original layout. So my question in reviewing this materials before this hearing is whether or not a variance is required at all. And I guess that would raise the question of does the board have authority to issue a variance when none is required?
I agree. That was well put. Thank you.
So in your judgment, these lots have not, despite the characterization by the town as a single lot, on the evidence you've seen so far, there are two separate lots in common ownership.
I ran the title. I didn't run the title. I went to the website and reviewed the title under the names of both of the current name of the Methodist Church here and the prior name, and found nothing to indicate that the governing body of that church had ever taken any action to combine the two lots. There's nothing on record at the registry of deeds.
Did you have any evidence? So you ran the title to currently?
Yes, from, I can't remember what. I ran the title from 1960.
To the present.
Up to some whatever date it was this week, maybe November 1st.
And Max, you have in your,
I couldn't, the computer system wouldn't let me print out the.
yeah, chain of title. I just have a question for Max when he's finished.
I'm sorry?
In your summary, you indicated the lots had been joined in 1974.
Right, so.
Yeah.
So this is what I was told by Daryl McKinney, the tax assessor's agent here in
Yes.
Waldeboro. So back in the 70s, Maine created the subdivision law, which I don't want to go through the whole thing, but essentially take one lot and split it into three, and you had to get planning board approval, and they made certain exemptions. What some tax assessors did, including the one here in Waldeboro did,
Yes,
was if you had two lots that had the same exact name on it,
right.
many of those tax assessors, unless they were told otherwise, just merged the lots together for lower tax reasons and for simplification reasons, and also not to, potentially have another subdivision issue if whoever had that back lot wanted to split that off and say, oh, well, it's technically three lots now. So it was all combined at that time. So the town did the merge without an actual deed from the United Methodist Church. And so that's sort of the question being raised here is, did the town go a bit too outside the bounds from doing that? And so,
And it may have depended on the ordinance at the time, because some ordinances provide that with respect to non-conforming, it's an automatic merger. And others don't. Ours doesn't make that automatic merger.
no,
But it may have, there may be something in the ordinance at that time.
in the 70s, I don't even think there was an ordinance at the time.
Yeah.
I think 1987 was our first ordinance, and that wouldn't have done anything for this type of merge.
Okay.
And there was a question in the audience for when citizens' comments would be allowed.
Well, first, there'll be, when we get to the details, then we'll have all the comments. We're just now getting to whether or not we even have jurisdiction or any authority to deal with this. So, but good question. I would say that, I'm looking for, how do we get for additional guidance? There is a provision in the ordinance. So for tax purposes, the town has merged them. It's not dispositive, it's just a piece of evidence. For ordinance purposes, the only thing I could find about that was that, let me see, this is the wrong set. It's in the ordinance. Just get the right reference. So it's in section 3.4. Now that section deals with public hearing requirements. So again, it's not directly, we're just looking, we're stretching here to try to find, stretching is the word, we're just trying to find bits and pieces of information or evidence that will help us make a judgment about this. So in 3.4, it says the owners of property shall be considered those against whom taxes are assessed. So in this case, what Max just said is that it was assessed against, combined into one and assessed against the church, and has been since that time. So it's just another piece of evidence. And again, we come back to the burden of proof question. You have obviously the applicant has the burden of proof that these are two. So if it behooves you now in your application, by the way, just to remind everyone, In your application, you're treating it as one. In your application, you're asking us to divide it and then to put the setbacks. In your application, you've restructured the lots altogether so that the smaller lot now becomes a lot with larger area because it takes pieces away from the larger lot. And then the larger lot gets cut somewhat to the distance that you're proposing so that it can be carved off from either the combined lot or from one of the two lots. So, but as I'm saying, you know, as you have positioned it, it's one lot that you're asking us to divide. So that's another piece of evidence. Again, we're just trying to put all the stuff in here that we can to try to make a decision. So that while the ordinance may not doesn't mandatorily require you, if you have, unlike some places, if you both lots are owned by the same people, it doesn't automatically require a merger in and of itself, and all other things being equal. We have the tax language, we have the ordinance language relating to that. So one would say, yeah, that does to some extent. And then we have your own language, which treats it as a single lot. But I'm happy to take a vote on whether it's
Well, so
one lot or two.
some of the questions that I think it raises are more complicated than other questions that we've dealt with before.
Yes,
For one thing, if, you know, due to the, you know, it seems like there's a conflict of laws here. There's what's gone on in the town of Waldoboro under the ordinance, under subdivision laws of the 70s, and then there's what the laws are, you know, and what goes on with regarding recording of deeds. So we do have two separate deeds, but we have, for tax assessing purposes, the town of Waldoboro considering this one lot, and I'm not sure which wins out. I just don't know the answer because it's not an area of law I practice. Secondly, if, let's say, is this a taking? If the town of Waldoboro decided that for, you know, these for tax assessing reasons, that they were going to combine these lots, and eventually what happens is it makes it so these parcels are, you can't, I mean, what we're saying, you know, what the applicant's saying is that there isn't a reasonable return. So you can't get a reasonable return in trying to sell these properties because of something that the town did that could be taking. That's a constitutional question, right? And these are kind of questions that usually would be kind of over our pay grade. I think as the Board of Appeals, and it might be something that we might need consultation with somebody who practices this area of law. I think it kind of raises some pretty important issues. Now, we could decide as a board that, you know, I mean, I think the applicants are saying this is one lot, but I mean, what is our authority as a board to say, no, these are two lots and we're not going to agree, and then they can sell the lots, and this is what's these are what the laws that will apply are. It seems like a very complicated issue that we aren't usually making decisions about. So it kind of gives me pause and makes me want to talk to somebody that does this work, for, you know, as a town attorney, or somebody that practices in this area specifically. And I don't know whether that would be something that the applicant would have the burden of doing that, or whether we should be looking into that. I don't know. This is just very complex in my mind.
so it seems to me if we want to be creative and go for something different from what the applicant requested, such as what Sandy is suggesting, then we do need, you know, town council to give us an opinion. And I don't believe getting an opinion from Maine Municipal Association would be, I wouldn't want to rely on that, but I'd have to rely on town council for that.
I agree.
Yeah.
I agree, and I do think that I don't know what the applicant's intentions would be, but I mean, I think certainly if they consulted with an attorney, this could become, you know, an issue of a taking, potentially. I don't know, you know, but those are the kind of the red flags that it sends up to me. So also, what happens if we decide, I mean, can we decide that it's two parcels? Can we just make that decision are we bound to what the applicant is?
You know, I think we need to consult with town council on that as well. I mean, where Sandy is going with his is that if it's one parcel, you're already in compliance. It's not a non-conforming lot. And because it's in the historic district, you're already in compliance. If instead it's properly characterized as two lots, then both lots are non-conforming. Maybe, I don't know what, if they are or not, because we don't have that information yet, because you were saying the way you might be drawing it, and I don't know, if this rendering is the correct, property line, so to speak, if it were two lots or not. That hasn't been introduced really here. But assuming that splitting them in half would then make them non-conforming, then the question is, if they're already pre-existing non-conforming, then that's one issue. If you want to split them and make what is a conforming lot now into two non-conforming lots, or one conforming and one non-conforming, then you have an issue that we have to address. And then there is a case law which says if you have, in this case, where you suppose, excuse me, suppose it's two lot, we're on the two lot theory. And let's even suppose that one of them is conforming and one of them is non-conforming. The state law, the case law says, if you're in that situation and you own both lots, you have to combine them in order to become conforming, in order to do things with them. So we've got that piece in there as well. In that case, let me see if I can find that case here. That's the case. Just so we can look at- Now, none of us are, Sandy and I are not Maine lawyers, and Natasha is a trial lawyer par excellence and currently working for the government on behalf of the citizens. So none of us are Maine real estate lawyers. We're just trying to do our best here, but we're going to need advice of town council or Maine council on this. I can take a look at that case. These cases are coming from the Maine Municipal Association manual. They got a manual to help boards of appeals work through this stuff. So it's not like I'm doing any legal research here. I'm just reading the manual. But they do have a case in here which talks about having to combine them both in potentially in this case, which I don't know the answer. Sorry. So the question is, we keep bumping into these hurdles. We don't know if you have standing. You're going to get some evidence that you do. We don't know if we have authority to declare these separate lots or not. And we have other legal issues that are now, we're trying to discuss. We're identifying them so that we can consult with counsel to get the answer. But I'm just thinking we're at this place where we need to, kind of adjourn the meeting until we have advice of counsel and until you have more information that can come in to support that that you have standing in the case. So that would be my recommendation. Do anybody have any other thoughts on that?
I support that, because I do think there's members of the public that want to comment. I don't know if that's an appropriate time to have them comment now, but I agree that I wouldn't be comfortable making any of these decisions without advice of counsel. It's not an area that I am familiar with, so.
I agree.
All right. So on that basis, I think I would just.
But I think maybe we need to give the applicant some guidance as to additional materials we need from them. The two things that come to my mind are some sort of documentation from the Waldoboro Church a copy of their resolution to dissolve or whatever it was they did. And also an explanation of this plot plan as to, particularly as to whether it redraws the line between the parsonage, the boundary between the parsonage and the church itself.
Forgive me, whether or not it does, did you say?
Yes.
Okay.
Yeah, if you can have, let me try rephrasing a little bit too, because I had that same question, Sammy. But what are the lines? What are the property lines if you go by the deeds? That's part A of Sandy's question, and then part B of his question is, are you proposing to redraw them?
Okay.
And just to add a little more detail, if you have the vote of the Waldoboro Church to dissolve, I still need a connection which says, and transfer our rights to sell the property to the conference, or maybe you have bylaws, maybe they're members of the conference. So things that will evidence their membership in the conference and their having signed on to by being such members. If that's the case, your authority, the conference's authority to dispose of the property in the event the Waldoboro Church votes to dissolve. Now, there may be other things in the votes that say, if somebody had drafted those votes, they would have said, we vote to dissolve and we hereby grant authority to the conference to dispose of the property, maybe even convey a deed, right? So the votes might have all that information, excuse me, but I just don't know till I see it. But that's what we're trying to find, a chain that where the Waldoboro Church gives you ownership of the property or the right to dispose of it.
May I ask a question?
Surely.
Sure. That section of the discipline that I read, take a step back. Local churches don't have the authority to give the church, that's wrong too. When they close, by our discipline, our code, all property reverts to the annual conference, whether it's in their resolution to close or not. So we never have that kind of verbiage in any of the motions about churches that are closing.
No, can I interrupt you?
Sure, absolutely.
So can you give us something which says the Waldoboro Church agreed to the document from which you read from, and I've forgotten the name of it.
Book of Discipline.
The discipline.
Yeah.
So that would be helpful.
I doubt that such a thing exists. I mean, the statement.
Yeah.
I doubt that they ever made that statement.
Well, when they come into the conference, how's it all formed?
Sure.
Yeah.
When the local church is formed, it's formed under the authority of our bishop, who gives permission for new congregation to be chartered. And it's a mission church initially. And then as it grows and becomes self-sufficient, it is chartered. And, sort of the imprimatur. And it is chartered and an active United Methodist Church as long as the congregation chooses to be active in ministry. And should they cease to be active in ministry,
Yes.
Probably want to get here. If they choose to cease to be in ministry, then the whole entity reverts to the annual conference.
If you give, maybe there's a charter that you could find for us. It's chartered.
That would have been in 1868.
Well,
And
1868?
yes.
Okay, this church was organized in the 1850s.
I can't remember. It's in that cessation, not cessation. The
Certificate of consent.
thank you. Yeah, that. It's in there.
I think the deed was at some point in the 1850s. The existence of this parish, it pre-exists the hierarchical structure that you're describing. And so maybe what we would need would be some sort of documentation that the parish agreed to, to submit itself to that hierarchy, when it was formed or at some point,
Just the folks that made the vote, right? I mean, the folks that, I'm sorry, are they a board? What is the?
Well, it would have been a church council of some sort. Each congregation can name it as it wishes.
So wouldn't the fact that they convened under, I would assume that the rules, the discipline.
Yes. And with what we call the district superintendent chairing the meeting.
So potentially, I would imagine potentially, right, it's an affidavit from superintendent, or I don't know.
Well, we probably have that it's that we don't have Waldeboro minutes. We only have affidavits of third parties.
or the documentation you get from the former officers of the local parish, if that reflects that they understood that these were the consequences of their vote to.
Yeah, and maybe your lawyer can talk about that.
Sure.
It's probably here. Well, we've got this. Well, how about this?
I think the system would come up with a title examination.
Exactly. Anytime, even when you sell the property, people are going to see the deed in one name, and then you're trying to send it. Who's going to sign? Right?
These certificate of successions are recorded with the deed when we sell a property. But I understand that you need something that says the people of the Waldeboro Church made the decision to close.
Right.
Okay. Oh, they decided on Saturday, April 17th, 2020, after careful prayer, study, and discernment on Saturday, April 17th, to properly call a church conference. The congregation gave thanks to God for their life. Waldeboro United Methodist Church in Waldeboro remained to be declared closed effective June 30th. So that was part of that resolution. The next to the last page of this certificate of succession.
That's not certified by Waldeboro folks. And it still doesn't say, even if they closed, doesn't say, and therefore the congregation or the conference, the annual conference can sell. It's that connection.
But that comes, and I don't mean to be argumentative.
No. That's what I say. It's going to be iterative back and forth.
Sure. Okay.
I think it says here that you further resolve the whole Waldeboro main directs with affirmation of the direct superintendent, the director of congregational development, et cetera, et cetera. It seems like they're acknowledging the hierarchy. And that,
Well,
right?
this motion that you're reading from now is actually the annual conference vote to officially close it, because the local church, the first paragraph talks about the local church taking that action.
Yeah.
And the second paragraph is saying, okay, now the annual conference, that's the body of clergy and lay people from all over New England who have voted. But then back to that, I hope I'm not being inappropriate, I'm sorry. Back to that first page that was a photocopy of the discipline, down at the bottom again, the last 5 lines. If the annual conference closes the local church, title to all the real and personal, tangible and intangible property, yada, 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 shall immediately vest in the annual conference board of trustees.
So we're looking for something that says Waldeboro Church agreed to that. Agreed to that discipline.
Okay.
That's what we're looking
And that's not, you don't, and I'm sorry, I'm not trying to be argumentative, but you don't find that to be in the law, in this RS 21-202, both the Waldeboro, the UNC, that narrative there, why doesn't, and I'm just, why doesn't that cut it?
because it's not from Waldeboro.
Because that's from the conference. So we need the voters, because I'm just wondering how the vote occurs, if it occurs at the conference.
No.
With those, how does that occur?
It occurred in the local church. Well, I don't know where the meeting actually took place, but it occurred here in Waldeboro with it would have been what we call a church conference, which is all of the members of the church, well, anybody can come and speak, but the members of the church, we have declared that, have the right to vote.
Yes,
And so, and it had to be a duly called meeting, at least 10 days, and announced through pulpit and bulletin and email and yada,
if you
yada.
can grab the minutes.
That's what I'm thinking, right?
Okay,
Yeah.
but just, I'll ask our counsel,
Yeah.
but I'm pretty sure that their motion would not have any language about giving their property over to the conference, because by our discipline.
Right.
That's what happens.
So let's get what pieces we can,
Okay,
right? So that's one piece, the close the church piece.
yeah,
Yeah, and to
And
me,
then-
the close the church piece is the, you know, as long as this is the hierarchy and the disciplines used, and that to me would probably be enough, but yeah, I think you're right. First piece is that they
Yeah,
made
they
that.
voted to close. And then the next one is they joined, they agreed to the discipline. Somehow, something they did or signed, they agreed to be bound by the discipline.
Or they're incorporated or something, right? That they're that they're.
And then,
that
yeah, the
might be
charter
the wrong
might say
word,
that.
But they're incorporated or they're literally part of the.
Charter might say that, or might not.
yes. Put that down. I'm guessing. I'm thinking about the history of the church, and Stan,
Yeah.
forgive me for being so familiar, Stan. That when the United Methodist Church was created in 1784, this was not part of our book of discipline. We had a discipline, it was tiny, but that was, we call it the trust clause, was not part of it. And I believe that came into effect, I think the year was 1812, that trust clause was included.
Mhm.
And whether the local congregations have put it into their deeds or not, courts all over the country have ruled in favor of the denomination
Yes,
to say that when a local church closes,
Yes.
it reverts.
good.
Because there've been people who have tried to say, well, this is our church. And within our form of governments, we call it polity. Lost my train of thought. That's just the way we operate. Matter of fact, some people in local churches say, well, the conference owns our property. We don't. The local board of trustees do. They hold it in trust for the annual conference, but they own it.
If you have, these are another bits of information, right? If you have any of those cases that might be interesting, or,
Okay,
you know, the charter that might say that, or whatever,
The
just.
church must have an attorney that's,
Yeah.
right, that puts these
I
things
got it.
together for.
well, yes, and the attorney created this, I can't remember.
Certificate? Yeah.
Yes, that certificate.
It all makes sense to me, but I do understand that we, make sure that it's incorporated, that makes sense. Or I don't think I'm using the wrong word, but,
We do, as a conference, we're incorporated. We're under the umbrella of the conference's incorporation. So each local church is not incorporated.
Yeah, it could be a trust form in some form.
Is that right? Okay.
Organized as some kind of association, might be a 501c3 or something.
what I literally mean is like it's under the wing.
Yeah,
But
she
I
wasn't
the
using
word I
the
can
name
think
of
of is, to
Well,
be
actually,
a
if
part
you look
of
at
the body
the,
of the church, I guess.
If you look at the second deed,
Yes,
the confirmatory deed, actually the conveyance is to the trustees of the United
right.
Methodist Church of Waldeboro.
And long historic names in the town. Yeah. Yeah. So, now, here's my dilemma with those of you who've asked to attend, who have come to speak. I know you'd like to be heard, and we would love to hear from you, but I think we should solve these things first, and then see if there's any point, right? And then have another meeting. But it seems like you're.
I just arrived today from New Jersey to attend this meeting. My husband is a pastor. He's on Zoom. I'm his wife, Aaron Person. We have an interest in the church to continue running for the township of Waldeboro as a community. And we've been in contact with several people in Waldeboro that would like to see it continue as a Christian church as it was before there's a chance for anything like this to even occur. It was marketed to
May I interrupt
us.
just a second?
Excuse me, I'm speaking. It was
I need
marketed
to ask
to
about her
us.
standing to speak.
It was marketed to us.
It's open to the public. So,
To anybody?
yes,
It was marketed to us through the multiple listing service as one property. And it came to us from the realtor by the name of Scott Lash, the broker that has it. And under the MLS listing, it came to us as one property listed, that it included the second property because 85 and 95 Friendship Road are the names of them on a deed because they added one later. And it's in the historic district, which is an area that you really don't want to change too much of that local feel. And having spent some time there, I've learned that people really need a church in the community and really want a church in the community more than not. And when my husband read the article that was in the Bangor Daily News about the church, 164-year-old church closing, what happened is there was at least maybe 8-10 people that expressed their brokenheartedness about their place of worship closing, and that all they really wanted was it to continue as a house of worship. And I tried to learn about how the newer building from the 60s, the early 60s, was put onto that plot of land. And that one parcel, what I've learned is that, and I do have the drawing of that lot. I don't know if you can see from here, but I'm happy to present it to you. The church is this larger building, and then the smaller piece here is the second building, and it goes all the way back where there would be a church parking capability. And this area here was all lawn, I've learned from your historic society, that the lawn was taken out in order for individual parking spaces to line up and a handicap access ramp and a handicap access that goes in between the two buildings, because this functioned as a church office, an area where there was council and other kinds of ministry activities in there. So I know that you might see two deeds, but this is the original building. And then this was the add-on from, I guess, 61 or something like 1961. And that area, that what we're looking to do.
can I just interrupt you? I mean, I think this is all information that may be useful, but we're not even at that point yet. So,
Right.
and you know, you can join by Zoom instead of coming up again at the
Okay.
next one. But
Okay, there was one thing I just wanted to mention to you. You have a property as a town of Waldeboro on Friendship. It's a Head Start school. And in your Head Start school plan that you request for proposals on, because we were trying to think where could we put a church in the area if this failed, because.
please,
I was about to say,
Yeah.
if you want to talk about the Friendship Street School, you can send an email to my office, but
Okay.
this should be about the
Just the
church
church,
specifically,
okay.
yes.
All right. That's just
all right.
to bring up the parking area.
So do I hear a motion to adjourn until
So moved.
second?
Second.
In favor? Aye, aye.
Aye.
Thank you.